Rise. The Justices of the Appellate Division, Supreme Court, First Department. ADD, all persons having business with the Appellate Division. You are here, your attendance, and shall be heard. Please be seated.
Good afternoon, everybody. Good afternoon, and welcome to the Appellate Division First Department. Nice to see everybody back in person again. As you will remember, we have had your briefs and your records and are familiar with your cases, so we ask that you please only ask for the time that you really need in making your argument. So I'm going to call the calendar. If you could stand when we call your case, appellant, tell me how much time, and respondent, and we'll get that all set up. So the first case on the calendar is People versus Johnson. Okay, submitted. Second case, Ferrara versus Active Temporaries. Okay, 5 and 2 and 5. Thank you. P. Children. Anybody? Okay, that case is submitted. Morris versus 1031. You're the appellant? Is the respondent here? No. Do you still want to argue for a few minutes, or do you want to just submit it? Okay, so we'll give you like 4 minutes, and the respondent, there's no one here. Okay, thank you. Stevenson versus Ghosh Hazra.
Appellant, 5 minutes, Your
Oh.
Honor.
Okay, 5 and 5. Thank you. Ormsby versus Time Warner Realty.
Appellant, 7 and 2.
And respondent? Okay, I'll give you appellant 5 and 2 and respondent cross appellants 5 and 2. Thank you. Richard versus Buck is submitted. People versus Meredith. Fine, 5, 2, and 5. Thank you. People versus Bavona. Submitted. State of New York versus AIG. Responded? There were two respondents in this case. What about the other? Okay, let's do 6 and 2, 5 for AIG, and 3 for the other respondent. Okay, if we have further questions, we'll keep you going. The lights are just for you to stop, not for us, if we have questions. The next case, Gurdjieff versus Lee Cool. I apologize if I got your client's name. There were too many consonants, I wasn't sure how to pronounce it, sorry. What, appellant? And okay, I'll give each of you 6 and 2 and 6 and 2. Thank you. 2015 Freeman versus Seneca Specialty.
Your Honor, appellant requests 7 and 4, please.
And respondent?
Respondent requests 4, 7 and 7.
Okay, 6 and 2 and 6. Thank you. People versus Vasquez is submitted. Fritchler versus Draper Management is submitted. Ayanu versus 1 BK Street is submitted, and the extra add-on Article 78 Dixon versus Scherzer is submitted. So as I said, please follow the lights, and if we still have questions, we'll keep you up there. The first case for oral argument is Ferrara versus Active Temporaries.
Good afternoon, Your Honors.
Good afternoon, counsel. You may begin.
Thank you, Your Honor. This case involves appellant's request that this court reverse the motion court's decision finding an issue of fact as to whether the whether the defendant Sanders was a special employee of plaintiff's employer, Pop Displays, such that plaintiff's claim will be barred by the workers' compensation statute since you cannot sue based on a co-employee's conduct. I submit to the court that the motion court's decision was erroneous because it relied on two improper factors. The contract between the appellant, Active Temporaries, which is the staffing agency, the Sanders general employer, and the special employer, POP, and it also improperly relied on the evidence of supervision on the specific night and instance. With respect to the contract between the general employer, Active Temporaries, and the special employer, POP, it's quiet on the issue of special employee status. And the Seminole case by the Court of Appeals, Thompson, dealt with the same issue and said when it's silent on the issue of whether or not the assigned employee is a special employee or not, the contract's not dispositive of all. The Thompson court also stated, secondly, and this is the second reason, that where the party, here the plaintiff, here the Sanders, the assigned employee, is not a party to that contract is not dispositive. And the Thompson court went on and stated, since it's not determined of this issue, it should not displace judicial assessment of whether or not here Sanders was a special employee. And instead, that question must determine on an examination of the manner, details, and ultimate result.
Yeah, so what did Pop do? How did Pop assume any control over Sanders in terms of Sanders' work?
So on the date of the accident, Sanders had been working there for 24 days. When he went to work there, he received his assignments exclusively from Pop. His assignments were given to him in a computer in a forklift that he operated that was given to him by Pop.
I think the judge below recognized that Active Temporaries had some kind of desk in the office on the site, and did that affect any of the assignments, or he seemed to rely partially on that factor?
I would submit is also erroneous, Judge. Whether there was a desk there or not has nothing to do with who controlled the manner, the results, and the method in which the work was performed.
And that would be true even if the check that Mr. Sanders was getting came directly from Active Temporaries as opposed to Pop. That's not determined.
It's not determined, Your Honor. There's a litany of cases cited in my paper, and it's commonplace in all these staffing agency cases that they're still going to issue the check, they're going to give the insurance. Doesn't have anything to do with controlling the work he was performing, and that's exactly what the issue is here. The second basis that the court was incorrect was they relied on supervision, and there's a case right on point, First Department case, Warner case, where a nurse was assigned to St. Luke's Hospital. Her general employer, the nurse worked without supervision, skilled employee, and the court there said you can't just rely on a supervision factor in determining whether or not it's special employment. You have to go to all the other factors.
Well, did Active exert any type of supervision over Sanders?
No, and that's also undisputed. That was submitted in affidavits, Your Honor, and there's no evidence whatsoever of supervision, and I'll address that in rebuttal. But a couple of the other key points were he was trained for 5 days by Pop. They made sure he could operate their equipment. They observed him with supervisors and forklift.
But he had prior experience as well, did he not?
Absolutely, Judge. But that's kind of a red herring. Just because he had prior experience didn't mean they trained him on their equipment. They had to train him on their equipment. Otherwise, they're opening themselves up for liability, and they did that for 5 days. So I don't think the fact that prior experience displaces the fact that Pop exercised control here because they trained him for 5 days. And importantly, Pop could ask for a replacement if they were dissatisfied with Sanders. And so that completely undermines the only Active could terminate the employee Sanders. And effectively, Pop did terminate him after
the accident.
After the accident,
But
yes.
You know, counsel, you made reference to the fact that their Active did, in fact, have a desk. Actually, my colleague made reference to the fact that Active did have a desk at the warehouse. So there was some testimony or evidence that there was a certain degree of supervision by Active within the warehouse of Sanders.
I would just say they did have a desk, but there was no one supervising Sanders' work. He would come in, check in, just because Active supplied employees, and POP was a big client. They needed to know their workers were there. They needed to know they were fulfilling their contractual obligations. So they made their guys check in, and once they started to work, they had nothing to do with them.
But Active kept the time.
Oh.
Active was the one that was keeping time, the time that Sanders was working, correct?
Yes. Yes, they control the time, monitor them, and that also goes to the wages to make sure they get paid the right amount of time for the hours they actually work for POP.
At the end of the day, isn't it a factual determination as to whether or not Sanders was a special employee of POP?
I don't think on the facts before this court, I don't think so, Your Honor. I list them at length with regard, starts with, he was there every day, he worked, he got his assignments from POP, he worked in POP's equipment, he worked at POP's warehouse, he was trained by POP, there's no evidence Active had anything to do with him on a day-to-day basis, what he was doing, where he was going, what work he was performing, whose benefit it was for.
Okay, you'll have 2 minutes on rebuttal.
Thank you, Your
Thank you
Honors.
very much.
Good afternoon, Your Honors.
Good afternoon.
James Ross for the respondent. The defendants in their brief cited many of the leading cases where special employment was found. There isn't a single one of those cases where the special employer admitted
Well, who had control over the plaintiff's work?
the
Who had
answer
control over the
is
manner in which he did his work?
the answer is nobody. Sanders
Nobody.
performed
Somebody
his-
had to have some type of supervision over the work. Someone had to tell him what he was supposed to do. Someone had to train him as to the equipment that he was going to use. I mentioned previously that the record showed that he did have prior experience, but there had to have been some supervision. It wasn't just like they threw him in the warehouse and, he did what he was going to do.
They transmitted his assignment electronically to Sanders at the beginning of his shift.
And when you say they, who do you mean, POP?
POP. And Sanders then received no further instructions in doing his work.
Okay, so how does Active become involved then?
Active, nobody supervised Sanders' work. Once he got his assignment, Sanders carried out his work based on his experience prior to working at POP. That was his testimony.
Look, he wasn't an independent contractor. Maybe he didn't need supervision what he was doing, but at the end of the day, if there was something which had to be adjusted or controlled or monitored, wasn't it POP who was doing that with Sanders?
No, there's no evidence whatsoever that POP exercised any control, that they gave any instruction to Sanders in performing his daily job.
I thought POP's, the individual who worked for POP, thought he testified that he had actually given Sanders instruction.
If you're referring to Pass Ram,
Rajendra supervisor.
Rajendra Lakenouth,
I'm sorry?
that's Rajendra Lakenouth, and
Yes.
Rajendra Lakenouth
Testified that he was involved in training Sanders, teaching him step by step during his first week at POP.
yes.
Testified he was there to correct Sanders and make sure that Sanders understood how to operate the machinery.
The first day of that 5-day period was Sanders taking a road test in which he demonstrated that he was proficient in operating the forklift. The next 4 days were...
Testified that he kept checking on Sanders, watching him drive to make sure he was doing everything correctly.
Yes, he checked on Sanders. And then, once Sanders got his unrestricted license, he was unsupervised.
But the thing is, he did say that he got, every day he got what he was supposed to do. I mean, he didn't come in day for day and say, well, what do I think I should do today? He got some kind of plans from POP, even if it was electronically or whatever. Active is a temporary agency. They find people to fill in for these jobs. They don't supervise them in any way. They pay their checks, maybe make sure that they're there. That's why they have the desk in the office, but they're not supervising them. So how do you say that POP isn't at least overseeing their work on a day-to-day basis?
Because they weren't. There is no test. Regindra Lake now testified that Sanders performed his job without supervision. That once he started working the night shift, he was unsupervised.
Does that mean that he didn't need anyone basically with him when he was operating the forklift? Not necessarily that he wasn't being supervised by act.
Yeah, without supervision seemed to me that what he meant was that it wasn't necessary for someone to continually look over his shoulder as he was performing his duties. Not that he was not being told by POP exactly what he was supposed to do.
He was never told by POP exactly. He was given his assignment. Bellamy versus Columbia, the mere giving of an assignment is not evidence of control. There is no evidence of any individual supervising Sanders. Sanders' own affidavit, he fails to name anyone who was a supervisor at POP over his work. He performed his work unsupervised. So the
Okay, does anyone have any further questions? Okay, I think we got your points, and thank you very much. We'll hear from the appellant. You have 2 minutes.
Briefly, Your Honors, in the event Mr. Sanders did not receive his assignment from the POP computer that was in the POP truck that he did his work for POP with on a daily basis, he would go to his supervisor and get the
His
assignment.
POP supervisor?
POP supervisor, thank you. Yes.
Is that Raj?
That was not Raj, that was Michael, I don't recall.
Okay, that's all right.
Off the top of my head, but it's in the papers. So it all goes back down to there is no evidence. There was 2 affidavits of the supervisors of Sanders on the night of the accident that are in the record. Now, Sanders didn't identify them, but they came forward and gave affidavits that they were supervisors on the night of the accident. They worked for POP, and they were supervising in his role working for POP. There was also a POP forklift supervisor, whose name I don't recall off the top of my head, but it was also working on the night of the accident. So, as Your Honors noted, he just doesn't walk in there and do whatever he wants. He does the assignments that POP give him for POP, and if there's an issue, he talks to his POP supervisor. Active's never mentioned in any of this analysis.
And POP also provided him with the tools and equipment as well.
Yes, exclusively. Yes, Your Honor.
Any further questions? Okay, well, I think we got both of your points. Thank you both very much.
Thank you.
And have a great afternoon. Thank you. The next case for argument is Morris versus 1031. And you are the appellant.
Yes, Jonathan Dax, representing the plaintiff appellant in this matter.
Okay.
In the absence of my adversary, I will make it briefer than I had planned.
Okay.
Although I never really understood the logic of that, but I'm sure the court will appreciate it. The court below, in my view, inexplicably seemed to go out of its way to ignore determinative facts and legal arguments, and clearly misapprehended the facts and the law in concluding that plaintiff's motion for summary judgment on liability should be denied. I'm well aware that the court is fully familiar with the facts, but to the extent that you'll allow me, I'd just like to emphasize a few facts that I believe are and were determinative. First of all, there's no doubt or dispute in this matter that the fog machine was owned, operated, controlled, maintained, set up, and inspected by the defendant in this case.
But wasn't there testimony that it was actually set up by somebody else, like another vendor that they had setting up these?
Yeah, Ms. Myers, who testified, she was the COO of
Right.
the defendant. She testified that she designed it, she had it built. I don't think she physically built it, but.
I also don't think she physically installed it.
No, I don't think she physically installed it either, but the
Didn't
defendants
Space
were.
Management construct a structure?
I'm sorry?
Didn't Space Management construct the?
Yes, it was a contractor on behalf of the
Right, but you just
defendant.
said it was undisputed that Ms. Mayer constructed it and installed it, but that's not correct.
Defendant did all those things and had somebody do it on their behalf. I do stand correct. But she and other individuals associated with the defendant she testified that they inspected all the attractions, including the fog machine, regularly to make sure that there were no problems. There was no doubt that the machine struck plaintiff.
Well, I'm sorry. She said that she checked the fog machines, but I don't believe that she said that she made sure that they were attached, or at least there was some dispute as to whether or not anyone was aware as to whether they were attached properly by cable wire, I think is what they said they normally were used to attach them.
Safety cable, yes.
Yeah. But I don't believe it. She said that she checked the cable or that she was aware as to whether it had been properly attached on that day.
She testified that she did not recall 100% whether a cable was installed.
Right.
And to cut to the chase, our position is whether a cable was installed or not. You know what, let me step back. First of all, her professed failure to recall is not something that should inure to defendant's benefit. But however, our position is whether a safety cable was or was not.
You were suing under a res ipsa.
General negligence and res ipsa, correct.
Okay, so, but you have to, there has to be some indication that she was aware of a dangerous situation. So how would she have been aware that there was a dangerous situation?
She was aware that people moved these devices. She was aware that they were installed as she requested. She was aware that there were
She wasn't aware that people moved them. She was possibly aware that they could be moved, I think is what she said, right?
Testimony
that
was.
They could have been dislodged.
Right, but there's no one else who would be able to know whether it was
But they
dislodged.
also had, there was also, a question, I thought someone testified, it may have been her, that they would check every day when they install these, and they might install them a little differently depending on the temperature, the wind, and all that. So there's a lot of different things involved with the setting up of these fog machines, and other people were doing it, not just her.
Yeah, but that doesn't let her off the hook, or her company. It's not her. It's
Well, I mean, we're not finding summary judgment for the defendant. We're just, we're just arguing whether or not you should have gotten partial summary judgment on liability, or
Well,
there should be a trial on the whole case.
I understand. Then let's talk for 1 minute that I probably have left about
You don't have
rate.
anything left, but you could talk for 30 seconds.
Thank you.
Okay.
On res ipsa, there's no question that we have.
Who had exclusive control? Let's talk about that. Who had
Sure,
exclusive
that's the
control?
issue, because they conceded the other two. There's exclusive control here because, well, there's exclusive control here because the fact that, as the judge found, other people were in the area or using the facility or walking through the maze does not indicate in any way, there's no evidence of any kind that anybody other than the defendants were responsible and in control of that device. It was hidden. It was on top of an 8-foot wall. It was dark. It was a dark facility. No one was supposed to see it. That's the way it was designed. And to suggest that somebody got up on a ladder in the middle of walking through the maze and detached a safety cable, if there was one, is not
Well, it wasn't that
likely.
they got up on a ladder, and it was also that because it's a tent, it's within the maze. I'm sorry, it's within a maze.
Right,
So, I
a
mean,
dark maze.
I thought it was that it could have been they could have been shaken or dismounted, or the mount could have shifted because of the constant traffic of folks walking on the ground in this maze.
And that's the dangerous condition that they had an obligation to eliminate. We have no evidence that that happened. The photographs show that the walls were
That's why
perpendicular.
the judge, I believe, denied partial summary judgment. Yes?
She did
Because
not-
there's an issue of fact. This is exactly what occurred.
No, there's no issue of fact that a machine on a shelf that weighs 27.6 pounds does not fall in the absence of negligence. And the only people in control and could exercise control over that, had a responsibility to control that, were the defendants.
Okay, we gave you a little extra time, so.
Thank you very
we got
much.
your full time, and I think we got your points. We'll take a look. Thank you very much.
Thank you. I refer to
And
my
have a good
briefs.
afternoon.
Thank you.
The next case for argument is Stevenson.
May it please the court, my name is Stanley Landers. I represent the appellant in this matter. The issue before the court is really easily stated. 4 individual defendants.
But how does your expert respond to what seems are two of the central points of Dr. Weissoff's reason why there was no malpractice here? And I referred to Dr. Weissoff's affirmation in paragraphs 26 and 27, where Dr. Weissoff makes the point that the tumor was only 12 millimeters, and had in fact, it would not have been immediately resected and rather would have been monitored with a repeat MRI. So he makes the point in paragraph 26 that you would not, for a 12 millimeter tumor, do a resuscitation yet. You'd have to watch it. And then he goes on to say in paragraph 27 that in any event, within a reasonable degree of medical certainty, that given the origination of CJ's tumor in the brainstem and its infiltrative nature, a complete resuscitation would be impossible. How does Dr. Bloomfield respond to those points at all?
He responds directly in 2 ways. First of all, he relies on the operative report of the surgeon who actually did the first operation on the child. And if you look at that operative report, which I quote at length in my papers, it says that the tumor is, quote, abutting, meaning right up to, but not penetrating the critical area. And what the doctor says is, and this is really very basic, he says, if this tumor were diagnosed and treated properly 8 months earlier, it would have been considerably smaller, depending on exactly when it began growing. And he says, I disagree, his exact words, I disagree with Dr. Wissoff. His name is Jeffrey Wissoff. And he says, if this were treated earlier, there could have been a complete resection. I want to...
Wissoff had stated that a tumor smaller than 12 millimeters would not be resected and would instead be monitored. So did Dr. Bloomfield specifically address that and say, no, that's incorrect? And why it would be incorrect?
I think the issue both of you honorable judges are addressing is this. If, in a motion for summary judgment, one expert opines, there are 4 different reasons why I feel this is unresectable, or that it made no difference. And in opposition to that, in this case, the plaintiff appellant's expert says, I disagree. If it's smaller, it wouldn't have been inoperable. It could have been completely resected. I don't think that the law in the state of New York is that if they raise 10 points about why there are...
Yeah, but where does Dr. Bloomfield take issue with Dr. Wissoff saying that you don't operate on a 12 millimeter tumor?
Okay.
I mean, just to add on to that, I mean, Dr. Wissoff specifically stated in his expert affirmation that this the 12 millimeter tumor would be too difficult to localize and resect, especially in light of its location in the brainstem, and thus the treatment would be monitoring for several months. So he didn't seem to address, I mean, your expert affidavit did not seem to go into any of the details that were raised by Dr. Wissoff or Dr. Chi for that matter.
You know, let me depart from everything I had planned on saying to the court and try to get at the essence of this. And maybe, since I'm not oblivious to the questions that the court is asking me, you might find this of some interest. And if I have 2 minutes left, I'll do that because
You have 25 seconds left, but go ahead.
Okay. In 45 years of doing plaintiff's medical malpractice work, I encountered 2 or 3 motions for summary judgment, mainly because their expert would say one thing, that nothing was done wrong, and an expert on the other side would say something was done wrong. And you'd get a decision, a question of fact.
Right.
I wonder if the court has any idea that in the last 2 years since the pandemic, I will tell you that although I have a small practice, I've probably had 10 motions for summary judgment in just these kinds of cases. One might ask, why is that? I answer in 2 ways. One, defense counsel can't go to court for 2 years. And I guess, what do they have to lose to make motions like this?
So, you know, counsel, what we're trying to get at is not that, as you said, you know, Dr. Wissoff has 10 things and therefore Dr. Bloomfield must address all of those 10 things. That is not what we're saying. At least that's not what I'm saying. The issue as to the size of the tumor and whether it should have been operated on, resected, et cetera, is germane to the med malpractice suit. It's germane to the issues. And so that's why, at least I was focused on whether your expert dealt with it or not. Because to me, and from reading the papers and your arguments, et cetera, it seems to be germane to the issues at hand.
And exactly what he said was it would be considerably smaller, maybe even 65% smaller and completely resectable. To me, that's a question not for a court, but for a jury, after they hear everything. This particular court said, your person isn't a pediatric neurosurgeon. That is a joke. A person who graduated from medical school yesterday.
We weren't focusing on that issue.
Yeah,
You didn't hear anyone ask you about that.
Right, we did not ask you about that. I recognize that your expert was a neurologist. Fine.
He was a neurosurgeon.
Was a neurosurgeon. I recognize that he wasn't a pediatric neurosurgeon, but the brain is a brain. So, I mean, I'm fine with the fact that he was a neurosurgeon. But I wasn't focused on that. I was focused on the size of the tumor and Dr. Bloomfield's not addressing Dr. Wissoff's statement or opinion concerning the size of the tumor.
Well, he absolutely did in great detail go into the size of the tumor.
Yeah, but even as to that, at one hand, he says it grows exponentially, and then he talks about a conservative analysis. So which is it?
The essence is that he said if this were treated properly, and by the way, I don't think it's insignificant that they don't even appeal the grounds for liability. What he says is no matter when this tumor started growing and the child started having a head tilt, which everybody called torticollis, which was totally incorrect, it would have been, if they had just gotten a simple MRI, they would have seen where the tumor was. It would have been anywhere between 65
You know, counsel, I had a question about that. Did you at any point in time argue that when the child was first presented to the hospital, that there should have been an MRI taken at that time, or any point during that period that there should have been an MRI done?
Well, it seems to me I don't have to argue anything about liability because they didn't even appeal it. This case is 100% liability. All they did was appeal causation. Nobody said that they shouldn't have done this. It was ridiculous. They all diagnosed that this kid had torticollis, and it's only congenital if you're born with it. Otherwise, there's something causing it, and he had it beginning at 11 months of age.
Counsel,
So,
I have a question. Did did the expert indicate whether or not he reviewed the MRIs, where the tumor originated from, and what would have been his treatment option? Was that ever discussed in the?
Well, absolutely. He said the basis of his opinion was the MRI that was taken 5 days before the surgery, which told him how large the tumor was, the location of the tumor, and the child's clinical history was. All these things were in the medical records, and the law of the state of New York
And his
is
review,
clear.
did he review it? Did he review it?
Absolutely.
Oh, okay.
It's even very much highlighted in my brief that that's the reason. If you base your opinion on facts that are in the medical record, the size of the tumor, the location of the tumor, the child's clinical history, those were the three things on which he based his opinion that the tumor would have been completely resectable, very much smaller. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. May it please the Court, my name is Jacqueline Mandel. I represent all of the defendants on this appeal.
So Dr. Bloomfield says at page A60 of the record, the key finding appears in the operative report of the first surgery on December 14, 2015. It states as follows: screening MR was done, which showed, I assume that means MRI was done, which showed a lesion in the left cerebral peduncle abutting but not invading the cervicomedullary junction. So as I understand plaintiff's counsel, he's saying that refutes your claim of the tumor being infiltrative in nature.
Your Honor, if you look in the supplemental appendix on page 20, you'll find the first page of the operative report that you're referring to, although the complete copy of it is in the supplemental appendix, not the main appendix. And you will see that the preoperative diagnosis and the postoperative diagnosis both say left cerebellar inferior peduncle infiltrating type tumor, likely low-grade astrocytoma. And the postoperative diagnosis says the same thing. Dr. Goodrich diagnosed this as an infiltrating tumor. Dr. Wissoff told you from his very detailed review of the MRI images that this was an infiltrating type tumor. In fact, both of the defendants' experts said that by its very nature, a pilocytic astrocytoma is born as an infiltrating tumor. And the plaintiff's expert never refuted that. In fact, the plaintiff's expert's affirmation doesn't even say the words pilocytic astrocytoma. He doesn't tell the court what kind of tumor it is. He doesn't tell the court the growth rate or where he comes up with the calculations for this purported growth rate that he's talking about. He doesn't talk about the characteristics of a pilocytic astrocytoma in general, much less as it applied to this child. He doesn't talk about how you treat a grade 1 pilocytic astrocytoma. There's nothing in there. We have an expert pediatric neurosurgeon and an expert pediatric neuro-oncologist, both of whom have devoted their careers to the treatment of pediatric brain tumors, and who explained in great detail what this tumor is, how you treat it, and why the delay made no difference. In fact, our experts also looked at the surgeon, who is Dr. Goodrich. That's the surgeon who operated on this child.
If it's infiltrative, it's not possible to just remove the whole thing. Is that?
Precisely correct, Your Honor. That's the nature of this tumor. And astrocytoma, it's kind of in its name. Astro, it's star-like, it has fingers. And it doesn't work like, and I know our experts talked about this as well, it doesn't work.
You say that's borne out even from the first surgery on December 14th, 2015.
I'm sorry, Your Honor, I didn't hear your question.
You say that's borne out even for the first surgery on December 14th, 2015.
That what is borne out?
That's what the surgery on December 14th, 2015 showed.
Yeah, it was an infiltrating tumor from in its nature. That's the nature of an astrocytoma. And this astrocytoma originated in 2 spots in this child's brainstem. Our experts very
And when
clearly
Dr.
said.
Bloomfield seems to say that it's something else that's simply contradicted by the facts.
Dr. Bloomfield doesn't say anything. He doesn't put a name to this tumor. It's an uncontroverted fact that this is a pilocytic astrocytoma. And nobody says anything to the contrary. The plaintiff's
He
expert.
uses the word abutting but not invading.
He does. I don't know. The operative report, Dr. Goodrich's operative report, and our experts' detailed explanation of the MRI images that they, unlike Dr. Bloomfield, actually reviewed, because there are no words in Dr. Bloomfield's 19 sentences to say that he ever looked at the MRI images, tell you that this is infiltrating, because a pilocytic astrocytoma is, by its nature, by definition, an infiltrating tumor that would not have been, this child's tumor would not have been fully resectable no matter when it was diagnosed. And I just want to address.
But counsel, to your adversary's point, you have Dr. Bloomfield, I recognize he's stating that it's abutting but not invading. But he does state that he believes that a complete resection of the tumor would have been curative. He also talks about the growth of the tumor. So again, why is that not enough to refute or address the statements made by plaintiffs?
Because, Your Honor, my light is on. May I answer your question?
Yes, yes, please.
Because it is the law in this court and has been for decades, in fact, it's the law in the state of New York, that an expert's opinion has to be based on facts in the record or facts personally known to the witness. And it is the law in this court that where an adversary's expert fails to address the specific assertions of the movement's expert, his opinions are merely conclusory and speculative. This court said it in Rotanti, in Ruiz, in Schechtman, in Biondi, in Stinson, in Rodriguez, and a few others that I'm not thinking of right now, that are all in my brief, that are all recent precedent from this court, that it's not enough to just say, I disagree. In fact, this decision's not in my brief, but it is from this court, and it was my appeal, so I'm just going to mention it. There was a case called Dejesus versus Misra. Judge Sachs wrote the opinion, and he said competing experts almost always disagree. The question to be resolved is whether there's a basis in the facts for that purportedly disagreeing opinion. I can get you the site of Dejesus if you need it, but it is this court, and it's, I don't know, at this point, maybe 8 years ago, I've sort of lost track of that. But that's the reason. It's not enough just to say, I disagree. You have to review the MRIs, and you have to review the medical records, and you have to review the deposition testimony, and you have to refute what the movement's experts say, and that didn't happen in this case. Thank you.
Thank you. Well, you didn't ask for time, so I think we got enough from both of you. We gave you both some extra time, so thank you very, very much, Counsel.
Thank you, Your Honor.
Have a nice afternoon. Excuse me. The next case for oral argument is Ormsby versus Time Warner Realty.
May it please the court, good afternoon, Your Honors. Christopher Della Carpini for the appellants, Mr. and Mrs. Ormsby. I'd like to turn first to the Section 240 claim. Justice Kahn and defendants give 3 reasons why Mr. Ormsby's injury is not protected by Section 240. The first of these is that the injury from a falling gang box lid here is supposedly a routine workplace risk. Your Honors, there is nothing routine about a defective and long neglected piece of equipment on a job site. If it's an ordinary workplace risk that the employers are not going to repair a device for months, as was conceded here in the case, recognized, then what is the labor law protecting? The second reason they gave was that raising the gang box lid was not an elevation-related risk. Well, it's certainly not the paradigmatic falling worker or falling object risk, but Section 240 is not limited to those two paradigms, those classic examples.
Are there any cases, I mean, where being injured by the lifting of the lid of a gang box is the basis for a 241 claim?
I don't see any cases either way on a gang box in Section 240. What I found was the Carr's decision that we cited in the reply brief, where the employee is hoisting a truss by himself up over his head, and he got summary judgment on that. He merited summary judgment in that circumstance. So elevating something by yourself can support a 240 claim. And that's what we have here. Mr. Ormsby testified to exactly how he's lifting this thing, and he gets it to about chest height, I think is the testimony. He's not lifting it overhead. There's no minimum height requirement in Section 240. This is a risk from elevation, as he tells. The problem is in trying to lift it without the hydraulics. What are the hydraulics there for? They're there to help you raise the lid.
Well, that, I mean, I think we could probably all agree with that. And I think in this particular case, there's no dispute that the hydraulic lifts were not working and have not been working for some time, but they knew about it. It wasn't a surprise. But isn't that kind of an action just a typical action? And although, you know, it may fall under a 241-6 claim, I'm having a little bit hard time analyzing it to a 240 subsection 1 claim.
As I've said, Your Honor, we don't find a case where it's happened before.
That's why.
There's nothing in the statutory language that precludes it here.
Well, when you look at the picture of the gang box, the first thing that comes to mind isn't that this is a 241 case.
I agree with you.
Yeah, we'd be looking for scaffolds and planks and things like that, but.
No, it's certainly not a scaffold, but we say it is
It's a
among
ground
other.
level, you know, it's sort of some just standing in front of it and taking what they need from the, I mean, that's why I say it. I mean, you're right that there's an elevation in the sense that the lid falls. So yes, that's gravity and that's falling from a height. But other than that, it's just a worker standing in front of the box and taking the tools that he needs while he's standing at ground level.
I think the pictures are clear, Your Honor. I think the danger that this presented, I like Mr. Ormsby described this, the only witness to the case, described this thing as coming down like a guillotine.
Right.
A guillotine is an elevation-related risk, I submit.
Do you want to go into some of the 241?
I do. Thank you. Justice Kahn had upheld much of the 241 claim, but not as to Industrial Code Section 23.2.1A1, because, as she rightly pointed out, this didn't occur in a passageway. That doesn't matter for our particular provision here. If you look at that provision, there's two sentences in it. The first is, all building materials shall be stored in a safe and orderly manner, period. It's the second part of that that talks about piles of materials that says they have to be stored securely so they don't obstruct the passageway or walkway. And there's good reason for that. Material piles present a risk in a walkway that they don't present in an open space. But the first part of this, that all materials have to be stored in a safe and orderly manner,
well, I don't know if the materials weren't stored in a safe and orderly manner. They were inside the gang box. The problem was the gang box itself didn't seem to be working properly.
I agree that the materials were kept safe. The workers who have to use them were not kept safe. That's the problem, and I think that's what this section protects.
But now what about there were two other sections that are still in from the way I read it, right? One that
That's right.
They mentioned till the reply brief, and one other that Judge Kahn specifically did leave in.
Yes,
It seems like 23-6.1B would not be something that should stay in, but since it wasn't raised in reply, until reply, it's your position that it shouldn't be considered.
That's right. That's settled in this court, yes.
Well, why don't we, there's one
have
section
rebuttal.
you didn't deal with. Well, let's hear from the other side, and then you
Certainly,
each will
Your Honor.
have 2 minutes for rebuttal. Thank you, Counselor.
Good afternoon, Your Honors. May it please the Court. Brendan Fitzpatrick, counsel for the respondents' appellants. First, if I could handle the 240 subsection 1 case. Your Honors, as this Court has pointed out, and we pointed out in our brief, there's numerous Court of Appeals decisions that we've cited to that simply because gravity is impacted, that doesn't mean it's a 240 sub 1 case. In particular, the Salazar case allegedly, case in that falling object, liability depends on whether the worker's task created an elevation-related risk of the kind that the safety devices listed in Section 241 were designed to protect against. Your Honor, as Justice Friedman pointed out, he's at a gang box, he's at the same level. He's actually taller than the gang box when he's originally with it. This isn't like Walensky, where the pipes were 10 feet high. They fell approximately 4 feet and struck the plaintiff in this case. Again, plaintiff's at the same level. It's 20 pounds for lifting the gang box lid. This is an ordinary workplace-related incident, has no business being covered by the extraordinary protections of Labor Law Section 240. Turning now to the industrial code provisions. 23-2.1A1 was correctly dismissed. Regardless of the sentence plaintiff wants to rely upon, this was an open area. This wasn't a passageway, it wasn't a stairway, it wasn't a walkway or a thoroughfare. That was the intent of that provision.
He says that the first sentence sort of stands on its own and isn't restricted only to a passageway.
The first sentence standing on its own, honestly, almost makes no sense. Where is that? Where are
Kind of a general sentence.
Exactly. When you have the specificity in the second sentence, which is the passageway, that's when this court in Burkowski and Militello specifically said open areas such as this, where plaintiff admitted this area was 200 feet by 200 feet, that doesn't apply to these kinds of cases. It's an open area. That's not what this provision was intended to apply to, and therefore I think it was correctly dismissed. Turning to the final two, 23-6.1b. Again, Your Honors, I acknowledge this was not addressed until the first time in reply, but that doesn't mean that it can't be addressed now, or that it couldn't have been addressed in the Supreme Court. After the defendants filed their summary judgment.
But it wasn't.
Oh,
I mean, he didn't have a chance to respond to it.
Your Honor, I don't necessarily agree with that. After the defendant's motion was marked fully submitted, plaintiff, and that argument was raised in reply, plaintiff filed their own summary judgment motion, where that argument could have been addressed, even if this court disagreed, though. Under Watson against City, where something is not influenced by the facts, and it's a legal issue that could not have been avoided on the face of the record, Your Honor, that's what we have here. This court in Gonzalez against Gledwood Mason Supply specifically ruled that 23-6.1b is too general to apply to support a subsection 241 subsection 6 claim.
Well, what about that one other section,
Finally.
requiring equipment to be kept in sound?
Yes.
To be kept sound and operable. It seems that the testimony I read was that your people knew, people on the site knew that the hydraulic lifts were not there, and the hydraulic lifts were obviously there to make it easier to lift the gang box. So isn't that at least a question of fact as to whether or not that would be the cause of the accident here?
Right. At the very least, there was a question of fact. But, Your Honors, I submit that this court's decision in Canty ruled that gang boxes were not the type of equipment that would be covered by this industrial code provision. The Supreme Court said that when this court made that ruling, the Supreme Court in Canty, the issue was essentially that.
Well, Judge Friedman and I we're both on Canty. I made a copy of that, and I think there's a distinction because they said nothing in the record reflected that the gang box was defective, but the record here reflects that the gang box was defective.
Well, that was the alternative ruling by this court. The first ruling was that it was inapplicable because the gang box was not unguarded or defective power equipment. That was this court's first ruling. Then the next sentence, it was, even if it was found that way, there was no evidence to support it.
Hydraulic pumps. There were no hydraulic pumps in Canty.
No, I don't believe there were, Your Honor. But the ruling that the gang box wasn't the covered equipment because a gang box isn't equipment. A gang box.
But here, it specifically stated that the hydraulic pumps were there in order to make it easier to open and close the lid, as Justice Kapnick stated. So
Yes.
if, in fact, you have this device and the device is not working, is inoperable, then why would that not, why would therefore we not find that there is at least an issue of fact as to that?
Initially, Your Honor, I would say that the gang box itself is a locker on wheels. It's not a piece of equipment. That's why this labor law industrial code provision would not apply. Whether it's this court, the second department, the fourth department, when they've all addressed this provision, it's all been with respect to hand tools, power tools, things that are used by the workers on the site, not something used to store a printer, a laptop, and personal effects.
Okay, well, let's hear from the appellant. You'll also have 2 minutes to respond. So, counsel, perhaps you can deal with that one section, and how is it distinguished from Canty, which I think it was, but let me hear what you have to say.
Well, I think when you talk about distinguishing, as Justice Kahn pointed out in Canty, she pointed out none of the case law that's cited in Canty was limited to power equipment. Neither is the language of the regulation limited to power equipment. And I think it's an important distinction in Canty. I don't think it's mere dicta in Canty that there was no allegation that the gang box was defective. It's undisputed here that this gang box was supposed to have working hydraulics. Mr. Wiseman, the project superintendent, testified it's supposed to have hydraulics to make it safer to raise and secure this piano-style lid. Mr. Ormsby testified to what it's like without that hydraulics working. This is as clear a violation of that section as you can get. Now, it's not the stuff inside the box that causes the injury, but it's something in the box, and it's due to the defect. And that
Do you read Canty as apparently your adversary does? Do you read Canty to hold that a defective gang box could never be considered could never be contemplated under the statute?
I don't think that's what Canty's saying. I think it's very important in Canty that the decision took the point to say there is no allegation of defect in the gang box lid. Canty's a different situation. There's another worker.
A co-worker who
knocks the gang box lid. So I think that makes it a fundamentally different fact scenario from here, where it's just our worker and this broken gang box.
Well, I think what Justice Friedman was saying, I think Canty dealt with a coworker who knocked a lid or something like that.
Precisely. I think that's a very important distinction in the fact pattern there. But that gets to a point I just want to make in the time I have on proximate cause. Justice Kahn denied the cross motion for partial summary judgment because she said Mr. Ormsby had not proven proximate cause. I think his testimony on this is clear. This is at page 565 through 570 in the transcript. And not only that, when he told his project, the shop steward, Mr. Iaccarino, what happened, Mr. Iaccarino immediately said, yeah, you probably tore your rotator cuff. It was obvious at the time. It's certainly obvious here, I think, to make a prima facie case of proximate cause. Thank you, Your Honor.
I think, by the way, just for future reference, I think Justice Kahn is a male judge, not a female judge.
Thank you, Your Honor.
Justice Kahn that was sat with us was a female judge, but I think Francis Kahn downtown is a...
And Marcy is not there.
Any event, doesn't affect the case, but I was just trying to figure out what she were talking about. All right, counsel, you have 2 minutes.
Thank you, Your Honor. Again, initially I would submit that whether it was under Canty or in this case, the gang box is not the kind of equipment that was intended to be covered by this provision. All of the cases that have cited, the appellate division cases that have decided address this issue, they don't talk about something that's used to simply store equipment. Even as recently as 2 or 3 weeks ago when with Justices Mendez and Kennedy, you were on the bench, a whip check. That was a piece of equipment used on a work site. It wasn't, that's something that would be covered by this provision. Same with a bobcat, a skid loader, a hand tool, a drill, a table saw. That's what this provision was talking about, not essentially what would be a locker on wheels. That's not what this provision was provided for. And unless the court has any questions, I'd ask to affirm those provisions that were dismissed and reverse on 1.53C and dismiss. Thank you, Your Honors.
Okay, thank you both very much. Have a great afternoon. The next case for oral argument is People versus Rasheem Meredith.
Good afternoon, Your Honors.
Good
My name is
afternoon.
Mark Zeno, and I represent Rasheem Meredith. May it please the court. Undercover 277 was the only witness to the 7 alleged drug sales. Defense counsel sought to impeach him with a federal lawsuit.
Were these sales videotaped?
They were, there was a camera phone running during all 7 of the sales. The videotapes were of varying quality and varying inculpatory value. Only a single one of the 7 sales was my client recognizable as the person who engaged in the sale.
Were all of them put into evidence?
They were all put into evidence, correct?
So you had videotapes of all 7 sales. You had, were there emails also or text messages to set up the buys as well?
There were.
And so I understand that the defense attorney wanted to question on UC 277. Yeah, UC 277 concerning this federal complaint, the federal case, right? The reason for that was it would go to credibility, right? To show that UC 277 was fabricating these 7 sales as he or she had allegedly done in the federal case. Is that correct?
Yes.
Given the fact that we have video of the 7 sales, we have the text messages setting up the sales, how would credibility now come into question?
Sure. UC 277 was an absolutely necessary witness. If he did not testify, the people didn't have a sufficient case, notwithstanding the video. As I said, the video only showed my client clearly in one of the sales. Notwithstanding the texts, because UC...
And don't forget the incriminating phone call at Rikers.
I'll get to that too, Judge. Notwithstanding the texts, the UC was a necessary witness to introduce those texts. The UC was a necessary witness for chain of custody of the drugs that were allegedly bought and sold. And without the UC's testimony, the people would not have had a sufficient case, notwithstanding the fact that my client admitted that that he was present during one of the sales.
We're not talking about without his testimony. What I was actually getting to was harmless error. Why would it not constitute harmless error by not allowing the examination of UC 277 as to this federal action?
Because the standard for harm under the Confrontation Clause in Davis v. Alaska says that you have to assume that the cross-examination that was cut short would have had the full force that cross-examination is intended to have, that essentially the jury would not have believed the undercover officer. And if the...
What you're suggesting is, had the jury heard that UCC had some implication in this federal case, they would have disregarded the 7 videotapes. They would have disregarded the Rikers phone call.
Not what I'm saying, Judge. What I'm saying is he was a necessary witness to prove a sufficient case. And if, notwithstanding the videotapes, the video footage, notwithstanding the Rikers call, they could not have made a sufficient case without the UC's testimony. And
again, that goes to credibility.
It absolutely goes to credibility.
And that's what I'm saying, that credibility does not appear to be an issue in this case based upon the videotapes, the text messages, and the Rikers call.
I disagree, Your Honor. If proper cross-examination had been allowed, the jury might not have believed anything the undercover said and would have discounted his testimony.
Even when we go to videotape?
Even when we go to the
watch the videotapes, 7, excuse me. You watch the 7 videotapes, etc. They're going to say, I'm not going to believe what I see. I'm going to believe something else.
There was one video that showed my client clearly. The other 6 did not. And that's the whole point of Davis v. Alaska and cross-examination. You have to assume that the cross-examination would have been effective. You have to assume that the jury would have believed that he lied before and falsely implicated someone else in 3 sales, and therefore he may have falsely implicated my client in this case.
Does the assumption have to be reasonable? You say you have to assume these things. Does it have to be a reasonable assumption under the facts?
Sure, it has to be a reasonable assumption. It could not be an unreasonable assumption.
And again, you're arguing that that would be a reasonable assumption.
That would absolutely be a reasonable assumption if that was the point of cross-examination, that if the jury had assumed that he lied before, falsely implicated someone in 3 sales, he may have falsely implicated my client in these. Thank you.
Thank you. You'll have a couple minutes on rebuttal. People?
Good afternoon, Your Honors. Emily Galt for the People. The court properly excluded cross-examination about the civil complaint that the undercover was named in because there was.
How? I do not understand how the court could have. You can argue that the court properly excluded this information. UC 277 was a plaintiff in the federal action, and the allegation was that he fabricated the evidence, or he lied about what occurred in those drug sales.
So
under what theory would that not be relevant in this trial?
So there was no specific allegation of misconduct by the undercover personally. The complaint generally alleged that the defendant officer, so it was the undercover and 2 other officers.
But this undercover.
So the complaint alleged that the defendant officers, yes, it did include the undercover 277, falsely claimed that the plaintiff in that case sold drugs to the undercover in this case, and that the defendant officers knew or reasonably should have known that the plaintiff wasn't the person who made the sales. And so
Well, counsel, I want to go a little further because there were also allegations that UCC 277 was part of a narcotics team and that UC 277 falsely indicated that he had purchased drugs 3 separate occasions. So it goes a little bit more than that.
So you're right, Your Honor. So, but the complaint said knew or reasonably should have known, and the defendant wanted to ask that question using that language. So even if the undercover answered that question, yes, it wouldn't necessarily mean he was a liar.
That's what a complaint says. I mean, you know, we all know that that's what a complaint is going to say in a civil suit. That's what it says: knew or should have known. I mean, that's how it's drafted.
Right. So the sales occurred in March of 2015, and the arrest of that plaintiff, Bradley, was in February of 2016, so it could have been an honest mistake. But the judge could have allowed the question at the trial for this defendant. He could have allowed it, and because it wouldn't have affected the case. Whatever the undercover...
So you're saying it was harmless error even?
I'm saying
it would have been harmless.
It would have been harmless error, but it wasn't an abuse of discretion either to not allow it. He could have allowed it, but it wasn't an abuse of discretion to not allow it because, like I said, there was no... The complaint didn't specifically allege that the undercover himself engaged in misconduct. So it was too general to be a question on cross-examination. But the judge could have allowed it, but he didn't, and it wasn't an abuse of discretion. And even if it was, which we submit to you, it was an error, it was absolutely harmless. As Your Honors pointed out, there were 7 video recordings of the 7 transactions. The defendant made a phone call at Rikers where he specifically admitted to being on one of the videos. He described exactly what he was wearing: a red sweatshirt, gray sweatpants. And in that video, you can see the defendant. It was from April 21st, which is the date of the first-degree sale, which was the highest count that he was convicted of.
But counsel said that the other 6 videos, camera videos, could not really identify the defendant. Is that true, that they were kind of valued?
Some of the videos were very blurry, but you can hear them, and everything that the undercover testified to in court, and then when you watch the videos, exactly what he's testifying to is exactly what happens in the videos. And in some of them, you can see the defendant's face. It is a little quick. It isn't a clear picture at all times, but the one from April 21st, which again is the date of the first-degree sale, you can clearly see the defendant's face, and he admits to being on in that video, wearing exactly what he's wearing in the video on the phone call.
Is that, yeah, that's what I was gonna ask, whether he admitted on the Riker's phone call that he was wearing exactly the same clothing
Yes.
that was shown in the video.
Yes. So on the Rikers phone call, he admits to being in the videos, and then he specifically he talks about the April 21st sale, which is a first-degree sale, and April 17th. On April 21st, he stated he was wearing glasses, a red sweatshirt, and gray sweatpants. And in the video, you can see him in glasses, a red sweatshirt, and gray sweatpants. And then for April 17th, he said he was in a gray sweatsuit, and you could see him in that video as well, in a gray sweatsuit. So if your honors have no questions at this time, we ask that you affirm. Thank you.
Thank you very much, counsel.
On the merits of the questioning, the facts here are exactly the same as in McGee, companion case to Smith. I raised that in the brief. The specificity is precisely the same. The people, the same respondent in McGee as we have here today, raised the same arguments they're making here. That's not even a question. It's the same, and the Court of Appeals found that it was an abuse of discretion not to allow the questioning. On the harm question, yes, as to 2 of the sales, my client admitted that that was him in the videos, as to 2 of the sales, not 7, not all of the videos. And if I could just use my last minute to address the Hinton point here, there was nothing about this case that made it the rare case where complete closure of the courtroom was warranted. This was
Didn't the judge permit the defendant's mother to be there and say that if there were anybody else that you wanted there, if you let me know who they were, I'll consider it, but they didn't bring anybody else, so it wasn't like a complete closure of the courtroom.
You're right. Thanks for correcting me, Your Honor. He did allow the mother and any other family members. But I guess the point I was trying to make is that the court closed the courtroom, finding that there was a substantial probability that the safety of the undercover would be jeopardized. When these sales took place in another county.
Well, we're talking Brooklyn, right? And so that's not that far, really. Yeah, right across the bridge. So and the judge made that statement. Talking Brooklyn, Manhattan. This undercover was pretty good in terms of his testimony, in terms of taking a side entrance or back entrance, not using the common elevators, not coming in the lobby of the courthouse with other individuals. And also, he testified, the undercover, he or she, testified that he had been threatened on multiple occasions with violence. So, the record seems to have been pretty clear in terms of why there was a need to prevent certain individuals other than family members from entering the courtroom.
Can I respond briefly, Your Honor?
Yes, please.
This is no different than any other undercover case. They're trained to have a list of things they can cite to that make their safety called into question.
Oh, you think they would lie?
That's not true at all. I think that they would tell the truth, but they have this list of factors, and they pick the ones that apply to them, and the court says, okay, there's a substantial probability that their safety is jeopardized. If the courtroom is closed in this situation, where it is in a different county, Sunset Park is not right next door to the New York County Courthouse.
But, counsel, if I may, the judge also indicated that that particular court part was frequented by many defendants and witnesses from South Brooklyn neighborhoods. And the undercover testified that he also had open pending cases in the South Brooklyn area.
But he didn't indicate that those cases were pending in New York County. And again, that raises the risk of making a citywide closure rule. The Court of Appeals and the United States Supreme Court has said it's supposed to be the rare case where you close a courtroom, even in a situation of an undercover. And undercovers are well-trained to cite the appropriate factors to close the courtroom, and it just happens routinely. And if it happens in this case, it'll happen in every case.
Okay, thank you very much. Thank you both. The next case for argument is State of New York versus AIG.
Good afternoon, Your Honors. While we're getting ready here, I just wanted to take a moment. It's Robert Sidorsky of Russo PLLC, and I would like to introduce my colleague, Max Maccabee of the D.C., Virginia, and Maryland bars, who has been admitted pro hoc vice and will be arguing on behalf of plaintiff appellant Alex Grabczewski, who is the relator in this action. Thank you.
Okay, thank you very much. Welcome, counsel.
Good afternoon. May it please the court. Max Maccabee for the state of New York, ex-rel Alex Grabczewski. Your Honor, this is a highly meritorious New York False Claims Act case seeking to recover tens of millions in unpaid insurance premium taxes for the state of New York that
Which New York authorities haven't been interested in going after.
Sorry?
Which New York authorities haven't been interested in pursuing.
Your Honor, respectfully disagree. In this case, and we did not note it in the papers, the state of New York intervened and settled with one of the co-defendants.
With AIG, yes.
MetLife, in this case. MetLife used to be a defendant, and MetLife paid insurance premium taxes to the state of New York in this case, and the state intervened. It's just that the state didn't intervene with this particularly challenging defendant who tries to overturn the entire insurance law as unconstitutional, like they tried to do in federal court against the DFS. They sued Losky and tried to overturn the whole thing as unconstitutional. They ended up settling for $35 million, AIG did, on unlicensed insurance activities, the basis of this complaint. But certainly the state of New York has taken action here.
For you to prevail, do you have to pierce the corporate veil between Group Management Division and AIG?
Your Honor, we submit we don't for a number of reasons. One, GMD, the sales unit, conducting the robust sales in New York, in Manhattan and White Plains to numerous international corporations authorized to do business, was part of AIG. It was coded 032 and paid by AIG as AIG.
That reflects its payroll status. That doesn't mean it's part of AIG. AIG is a Delaware corporation. The bar of piercing the corporate veil in Delaware is not an easy one to meet.
Your Honor, we contend we have additional facts that made GMD in effect AIG, not just the payroll code.
You have the payroll code, you have the email, right? You're stating
Emails.
that the email also had
Reporting structure, they reported directly to AIG. Also, AIG paid their bonuses. AIG actually approved their bonuses, reviewed them and approved them, and AIG would fire them. AIG officers fired my client when he complained about this conduct. We submit that from 2002 to 2007, GMD was actually AIG, and under any respondent superior theory, AIG is liable. But also, we want to also point out that we contend that AIG is liable under a agency and joint and several liability with AIA. Joint and several liability is a knowing participant in a tainted transaction. AIA receiving all millions, tens of millions in premiums, actually hundreds of millions. AIG was a knowing participant in helping with the reporting, with the structure, with the bonuses. We cut and pasted the bonus pages into the complaint where you can see if the salesperson earned over $50,000 or over $100,000 or over $150,000, you had AIG officers actually approving and AIA officers approving on the same page. Also, the bonus letters, the incentive comp letters had AIG letterhead on it, and Rob Martin, an AIG officer, was actually the person approving the largest bonuses. We feel, or we contend that we have pled more than sufficient facts that veil piercing is not needed. Your Honor, we contend that the lower court erred in dismissing, number one, that GMD was not conducting an insurance business. We robustly pled under Insurance Law 1101 that making or proposing to make or soliciting was very actively done over many years. We pled that. We pled specific companies. And it's not just our pleading. The state of New York...
Do you plead that AIG, as opposed to ALICO, made a false claims or statement to New York?
Yes, we do, Your Honor.
Where do you say that?
So the false statement among,
By AIG?
yes, AIG. So the state of New York in the consent order decided or factually found that the representations made in 2009 to the Department of Insurance were misleading and fraudulent, and it's in the consent order. And we pled that AIG officers were present when the misrepresentations were made. The district attorney's office said that they determined that they could institute a criminal prosecution against one or more of the MetLife parties for criminal conduct for violating Section 1101, doing an insurance business. And that was based on that same misrepresentation. Now,
But what you said, I thought you said that AIG was there when it was said, but what did they actually say that was false or misleading?
so they in 2009, pursuant to paying off the TARP debt, they were going to sell off their subsidiary Alico. They asked for a letter of opinion from the Department of Insurance. It's 89 in the record. And in the letter of opinion, they represented that GMD was not doing any insurance activity. And they were warned specifically by the Department of Insurance that if they were doing more than back office functions, provided there is no contact with the public, and they do not involve the solicitation or sales of insurance activity, that they can remain in New York unlicensed. That's a specific warning, and that was a point we made in the knowledge section, that specific warnings that you are running afoul of the law is sufficient to establish knowledge. They then were found, when they did a PowerPoint presentation to the Department of Insurance, to Mr. Losky. AIG officers were present. AIG, also in the letter representations to the Department of Insurance, they cited AIG officers in the letter. So, including Rob Martin, an AIG officer, saying they weren't doing any insurance activity. Well, we contend we have sufficiently pled facts to show knowledge just on that alone. Also, at the same time, they were lobbying the state of New York to change the law, saying that at present you can market your insurance products to New York corporations like here, even for out-of-state risk. Well, if they're lobbying the state of New York, clearly they had contemporaneous knowledge that the law said what it said. They're attempting to assert a reasonable...
That doesn't necessarily follow. There may be varying interpretations, and they just want to make sure that they're on the right side of those interpretations.
Your Honor, that very well could be true, but in facts construed in favor of the relator at this time for a motion to dismiss, we contend the facts should be construed in our favor, that they're trying to lobby to change the law because they're running afoul of it, precisely. But more important, they're asserting a reason...
Can you really make that jump, that because they're lobbying to change the law, that they're running afoul of the law? I don't know that... I don't see how you make that jump.
Maybe you don't jump that far, but at least you can make the inference that they were aware that that's what the law said. Because they're saying that they had a reasonable interpretation defense, that they were unaware that the law said that if you market to New York corporations for risk overseas, that you have to have a license. They say, oh, we didn't know that. Same with the tax. But if you're lobbying to change the law, doesn't the inference mean that you know what it says?
What they were selling did not involve New York risk.
Your Honor, so for doing an insurance business under 1101, proposing to make, or soliciting insurance to a New York resident or a corporation in New York requires a license, regardless of whether the risk is overseas. We listed no less than 6 insurance opinions during that time period that said exactly the same thing, that selling to New Yorkers for insurance in Peru, for Peruvian doctors, requires a license. Insuring to Dominicans in New York for risk in the Dominican Republic requires a license. It was crystal clear during this relevant time period that out-of-state risk, so long as you're marketing and selling to a New York resident, requires a license, and for good reason. New York wants to protect its citizens from unscrupulous or insolvent insurers who are selling to them in New York, even where the risk is out of state. Now, with the tax question.
Okay, we've given you a little bit of extra time, so why don't we hear from the other side, so you'll have a few minutes to respond, okay?
Thank you.
Thank you very much. Are you counsel for AIG?
Yes, Your Honor. William Burke for AIG. Thank you, Your Honor. Thank you. May it please the Court. The one thing I think it's important to focus on, based on what my colleague said, and what he didn't say, is he didn't talk about what the court below found with respect to if you assume it was a life insurance business, this was a life insurance business, it was either licensed or it was unlicensed. And as the court below said, if it's unlicensed insurance business, there's no franchise tax owed. And even if it is licensed, even if they were licensed, which is a counterfactual, because all of the risk and all of the residents were outside of New York, outside the United States, Your Honor, Your Honors, then there's no franchise tax owed. And that was based on advisory opinions, multiple advisory opinions, uniformly saying the same thing from the Commissioner of Taxation and Finance for the state of New York. So the court said, I agree.
Has that law been changed since the time of this?
It has, Your Honor. It was actually changed in 2012 because the state of New York decided they wanted to change the law. And so in 2012 was after AIG had sold Alico, GMD, and AIA, or spun off AIA and sold Alico and GMD to MetLife. So this all happened afterwards. So, Your Honor, the point that my colleague doesn't address at all is that the court, even putting aside the question of the insurance business, the court said, I believe that the advisory opinion was correct, that the law at the time said that an entity like GMD, Alico, AIA, AIG, with respect to non-New York risks, non-New York residents, licensed or unlicensed, no franchise taxes owed. And then the court said, and this is something I think is impossible for my colleague to get around, he said that there's no way to conclude there was a knowing violation of the law when AIG and all the other, and Alico and AIA, could all rely on the fact there were advisory opinions telling them they don't owe franchise taxes. So if you just stop there, you just look at whether or not franchise taxes were owed, there's no case, because that's the entire gravamen of the case. And then now on appeal—
What was the time frame for when it got to MetLife? Was that after the law was changed?
This was before, Your Honor. The AIG sold the businesses that are issued here
2010?
In 2010. And then the law was changed in 2012.
But what about MetLife? You said MetLife entered into a consent order?
Yes, MetLife entered into a consent order. I believe it was in 2014 or I'm sorry, it may have been later than that, Your Honor. I think it might be 2016. But they entered into a consent order that AIG had nothing to do with.
But AIG paid too.
AIG, Your Honor, that was a completely different situation. So in that case, by the way, it was a no consent, a no admit, no deny from AIG's perspective. It was a case in which DFS was alleging that AIG had engaged in unlicensed insurance business in the state of New York. There was, as my colleague mentioned, AIG sued DFS in federal court, and that lawsuit saying that this was an unconstitutional extension of New York jurisdiction beyond the bounds of New York and would violate the Commerce Clause, et cetera. And as a result of the litigation, AIG did settle the case, but they did not admit that it was an insurance business, that it was conducting insurance business in the state of New York. It did not deny it as well, but that was the deal. And of course, as the court knows, cases get settled all the time for all kinds of reasons. But one thing to note is that this judge, again, I don't even think the court needs to even reach this issue in order to find that there's no case, that the decision below should be affirmed, because in this case, the court below found that they agreed with AIG's opinion, or vision of the law, which was that it was not conducting insurance business in New York because there were no risks, no residents in New York. And again, the court said, even if that's not correct, it's clearly a reasonable reading of the law to say that the way it's written, clearly a reasonable person would think, well, it doesn't cover us. So even then, you don't have a knowing violation. But again, Your Honor, you don't even have to reach any of that, because there's no way for the appellant to get around the first point, which is that licensed or unlicensed life insurance business, at the time, no franchise taxes are owed. There's really no way to dispute that.
Licensed or unlicensed?
Licensed or unlicensed. And Judge, I think that they even conceded effectively an appeal, because something they did not raise below, which they haven't preserved, therefore, but I would raise it because I think it highlights the fact they have no argument to counter what the court found below about the question of licensed or unlicensed life insurance not requiring or leading to franchise taxes.
And was that all they did? Was there ever any allegation that they did anything but that
No,
life insurance?
no, Your Honor.
business?
And in fact, the appellant now says that in fact, and this, I don't understand how this argument is made, but they do make the argument, that in fact, the tax laws, which they bring the False Claims Act under, do not apply to AIG. That's what they say. If that's the case, then we're not sure why we're here. Because if they're now saying that those laws do not apply to AIG, then there's no basis to even allege that AIG committed a false claim. But they're saying that because they realize there's no way to get around the advisory opinions and to get around the fact that there was no question that at the time that these activities were going on, AIG...
In the first instance, it's your position that what GMD was doing did not constitute insurance business in New York. If it does not constitute insurance business, there's no franchise tax due on it by AIG, certainly, and therefore there's no case.
That's one argument, Your Honor. We also say that even if there was life insurance, it was a life insurance business, it was licensed or unlicensed, the advisory opinions at the time said that because the risks were not in New York, that therefore there's no franchise tax owed. So the point is that no matter how you look at it, at the end of the day, at the time this was going on, even if you assume, which we don't think is correct, but even if you assume that we were conducting a life insurance business, if we were unlicensed, then no question, no franchise tax was owed. If we were licensed, the court said below that means that it has to be a risk. It has to be a risk, a New York risk, and that was not present here. So at the end of the day, there's no way for the appellant to get around that. And that's, again, why I think they now claim, first time in appeal, which completely contradicts their complaint, that these tax laws did not apply to AIG. I don't understand how they then can still have a case, but that's what they allege now. So they've changed their theory. They've contradicted their complaint.
Okay. Any other questions? Thank you very much, counsel.
Thank you, Your Honor.
We'll hear from your co-defendant.
Good afternoon, Your Honors. May it please the Court, Leif Simonson of Cobra and Kim for Respondent AIA Group Limited. In addition to all the reasons stated by counsel for AIG, there are additional alternative grounds on which the Court may affirm the lower court's order dismissing all the claims against AIA Group Limited. Foremost, plaintiff has failed to make a prima facie case of personal jurisdiction over AIA Group Limited, nor has plaintiff met the standard necessary to subject AIA Group Limited to jurisdictional discovery. AIA Group Limited is an investment holding company incorporated and headquartered in Hong Kong. All of plaintiff's allegations relating to New York contacts and activities are with respect to a different entity, AIA Company Limited, or AIA, not AIA Group Limited. AIA Group Limited did not even come into existence until 2009, at which time it purchased AIA's shares. AIA is now AIA Group Limited's principal operating subsidiary, and plaintiff offers no basis to impute the activities or contacts of AIA to AIA Group Limited. Under New York law, the general rule is that when a corporation acquires another corporation, it doesn't become liable for its torts, and none of the exceptions to that general rule apply here. Plaintiff offers allegations that AIA Group Limited assumed AIA's assets and liabilities, but those are mere legal conclusions, and they are moreover flatly contradicted by the documentary evidence that we offered in our motion to dismiss. New York law is very clear that when a corporation purchases another corporation's shares, it does not subject itself to successor liability, and that's all we have here. And plaintiff cites no case to the contrary. All of plaintiff's cases involve more than mere stock purchases, including asset purchasers and other elements that are not present here. And moreover, plaintiff's allegations are insufficient to subject AIA Group Limited to jurisdictional discovery. New York law is very clear that to be entitled to jurisdictional discovery, a plaintiff needs to offer some tangible evidence that constitutes a sufficient start of a showing of jurisdiction. And plaintiff comes nowhere near meeting that standard here. And plaintiff can't meet this standard merely by speculating that there may have been some transaction elsewhere whereby it may have AIA Group Limited may have acquired or assumed its liabilities. I see that my red light is up. If the court has no further questions, I would just ask that.
Well, I mean, how are they supposed to know that if they don't see the agreement entered into by the two corporations? How do they know what the two corporations agreed to do?
Well, Your Honor, in this case, all of their allegations, they cited the prospectus, and they cited the fact that AIA Group Limited acquired AIA Company, and they, by virtue of that, they incorporated by reference the prospectus and the documents referenced therein, and those documents clearly show that this was merely a purchase of shares. This was not an acquisition of any assets or an assumption of liability. And clearly, if a plaintiff could just stand up and say, well, how am I supposed to know I'm entitled to jurisdictional discovery, then there'd really be no limit to jurisdictional discovery. Thank you.
Okay, thank you. All right, counsel, you have a few minutes to respond.
Your Honors, to answer your question, MetLife did settle in this case as a defendant and paid taxes. Now, with the state of New York. Now, we've never changed any theory in this case. My colleague is respectfully incorrect. We raised, their entire tax case depends on 4 advisory opinions in the 2000s. If the court, a plain reading of those tax opinions, in each instance, it was an out-of-state insurance company, unlicensed in New York, doing ordinary business in New York. One was selling a building on Fifth Avenue. Another was loaning money on commercial real estate. None were doing any insurance work in New York. The question before the Department of Taxation was, do we owe a tax under Article 9A, ordinary business tax, or under Article 33, insurance tax? Now, Article 9A says, if you're an insurer, you only owe Article 33 taxes. You don't owe 9A for ordinary business. At the time, for life insurance companies, the Department of Taxation said, well, if you're 0 under Article 33, because you're not actually earning any premiums, you're not doing any insurance work, you're 0 under Article 9A. If we were suing AIG right now for selling a building on Fifth Avenue, ordinary business, we agree with counsel, those opinions apply. If we were suing AIG for mortgage, loaning commercial loans on property, we agree the advisory opinions apply, but those advisory opinions, none of those insurers were marketing or selling insurance in New York or earning premiums. That's why if you read those opinions, you'll see there's no premiums earned by any company except...
Well, I mean, they're saying in the first instance that they were not involved in insurance business. They were saying even a licensed or unlicensed life insurance sales would not require franchise taxes.
And they did. They emphatically did. In earning hundreds of millions of dollars in premiums in New York, AIG owed a tax on those premiums. So did AIA. It's that simple. I know they say they don't owe it, but they do. And those opinions only were attributed to life insurance companies. We pled that they also sold like medical insurance in our complaint, other types, pension funds, they had insurance services. They're actually disqualified as life insurance companies under the tax law. The insurance law disqualifies them under insurance law 4205 if it's not one of 6 types of insurance policies. One of being they were selling medical. They are disqualified as a life insurance company to avail themselves of those opinions. But the opinions are completely irrelevant. They weren't doing ordinary business in New York. They were selling insurance. And if their whole case depends on that argument, which we did raise below, the argument fails. Now, AIA, we found out in the appeal that AIA actually still exists, and it's now the operating company. Well, we would have pled the operating company as the real defendant had we known that. But in discussions with counsel, we were led to believe it was AIA,
So you thought that AIA, which is a non-party, was out of business, and so you did not?
we understood that AIA was extinguished, and we pled it that way in discussions with AIA's counsel. Then we found out in the appeal that it still exists. And it's actually an entity that is the operating company. We don't know where the assets, the insurance contracts, billions in insurance contracts, or all the personnel, the infrastructure, we don't know where that is. We don't know if that's the operating company. We don't know if it's that's the parent company. But if you actually look at the asset purchase agreement that they finally produced in the appeal, it makes it seem like there is implied or express assumption of tort liability under Section 7 and Sections 9. If you read them, it seems to indicate they are liable for unpaid taxes after the sale.
Okay. Does anybody else have any more questions? Well, I think you all brought up a lot of things, so we will certainly take another look, and thank you all very much for coming.
Appreciate it. Thank you.
Omer Gurdjieff versus Liku.
Gergerev, Your Honor.
What's it?
Gergerev.
Gergerev? Okay. Sorry about that.
That's okay.
Okay, counsel, you may begin. Good afternoon.
Good afternoon, and may it please the court, my name is David Slarsky, counsel for the appellants Ferdo and Omer Gergerev. This equitable dissolution special proceeding arises out of a dispute among the two shareholder factions of Oconomled, which for the last 2 decades has owned and operated Delmonico's Steakhouse in Wall Street.
So now is it open now, or is it not open now?
It is not open now.
Okay, and it hasn't been open since the pandemic?
It has not been open since the pandemic.
Okay, question. The only thing that you're appealing, affirmatively appealing, is to direct the respondents to produce an accounting for 2011 to 2019, is that right?
That's correct, Your Honor.
So you got books and records, they were made available to you, but you didn't get a formal accounting for that period of time. So if we granted you a formal accounting on that, you'd have to open up this entire case, and that would, you'd have to do an amended judgment, because I see your judgment's been entered for almost a year now.
Your Honor, there's a lot to unpack in that question. There have been documents produced. All of the electronic data was destroyed by the petitioners. There was no accounting produced in the record. The referee who overseed the proceeding evaluated.
To grant you relief on your appeal, what is it that you're going to get that you don't have now?
There are effectively 2 sources of relief that our clients have been looking for, Justice Frieden. The first was for the equitable dissolution so that they could take over the corporation. But the second, what they've been looking for...
They got that, right?
They got that. Right. What they've been looking for since 2013, however, is this is a company that has reported revenues of $70 million. Reported. The tax returns were found to have material misstatements on them in terms of distributions to the shareholders that weren't made. Back in 2013, my clients started asking for an accounting because they saw all this cash coming in.
If you prevailed on this claim, what's going to happen?
If we prevail on this claim, the matter goes back to the trial court, and respondents will be asked to produce an account. They will ask to account for the revenues and the assets of the corporation for the period of time that they haven't accounted for.
So I did look at the referee's report. It was a lengthy report. Mr. Chang, I believe, was the referee. But so you didn't get any, I mean, he didn't attribute anything for that period of time. He only attributed up until 2011?
This goes to the cross appeal, but the way he calculated relief, the only monetary relief my clients got, first of all, he valued the restaurant at $5 million.
Right.
Okay? And having found that there was shareholder oppression, he said, fine, you pay $2.5 million, you get their 50%, okay? Then he came up with a judgment based upon the failure to distribute reported shareholder distributions that weren't made.
You didn't get any after
didn't
a
get
certain
anything.
point, and that was clear.
Exactly. So we got the distributions that should have been distributed that weren't, and then we got the millions in excess salary that they took between 2015 for themselves. What we did not get, and what is glaringly missing from the record, is an accounting for the $70 million or the $35 million in quote-unquote expenses that they claimed on their tax returns. Now, was some of that legitimate? Of course. They were running a business. But they're taking $2 million a year in cash out of the business, and they claim $30 million in vendor expenses, which they have never accounted for. There are no books and
How are you
records
getting
to tie
to the
that out.
bottom of that beyond what the referee has already done?
I'm sorry?
How are you getting to the bottom of that beyond what the referee has already done?
Well, that's a question really for the respondents. The referee shifted the burden onto us and said, if you can't prove that they stole the money, then you don't get relief for that period of time. And Justice Friedman, it's your cases that you heard, In re Sakow, Polish American, Mullen, these are all cases that stand for the proposition that the fiduciaries have the obligation to account. If they can't account because they've destroyed the books and records, they didn't maintain books and records, or whatever else they did, because they're trying to conceal from the court and conceal from their partners what's going on with the cash in the business, they're held responsible for that, Your Honor. And we got no relief on the failure to account for the assets of the corporation. All we got was relief on their taking millions in excess salary, which was part of the reported salary, part of the reported revenue, and their failure to distribute the reported.
So you got 1.7 million, right?
It was a $1.9 million judgment.
1.9 million. So now again,
On, Your Honor, on a $70 million, there's $70 million.
I'm just trying to figure out, so again, what you're talking about, you want the accounting for 2011 through 2019, and so to show what? That
Show what happened to the $70 or $45 million that we saw nothing of. We don't even know if that number is real.
They deleted all of the electronic, the POSs, right? They deleted those.
They deleted those when they were ordered by Justice Schechter to turn them over.
Okay, but they deleted those, and so I'm still trying to figure out what the additional account, what you're now accounting, because there doesn't appear to be any records.
It's almost inconceivable to me that these gentlemen who are running this business, this is not a mom and pop operation. They know what happened to the money. They know where the money went, okay? They have never been ordered to show where the money went or to tie out books.
But didn't the referee do this? Didn't Chang, didn't he look at all of this?
No, Your Honor, he did not. What he did is he retained an expert who reported on the state of the accounting practices from 2017 to 2020. Mr. Reckman clearly had a limited cabin, and he testified that what he found was a wholly inadequate accounting environment.
But he never went beyond to see exactly what the numbers
He never went
were.
beyond. And then our expert, who came in, who's been adopted by the court before in a similar case, said, there are no books and records to tie these numbers to. You have tax returns that claim revenues and expenses, but you can't tie them to anything. Now, Your Honor, they should be directed to provide a
So they should have the burden on this, is what you're saying.
Exactly.
To prove an accounting and to prove, something. And I mean, I'm not exactly sure how that'll happen. I guess maybe there'll be.
Well, the Polish American case says what happens. The Polish American case says if you're a fiduciary and you're running a business and you have
Then
investors,
there's a negative inference or something that comes.
there's a negative inference, and you can be held liable if you can't substantiate the records. This is a major moral hazard problem, Your Honor, because what this court did below is it effectively cleared the decks for these fiduciaries who were running a $10 million a year business. It cleared the decks for them without giving any accounting for the assets to their investors.
Okay. All right. You'll have a few minutes in rebuttal. Let's hear from the respondent. Thank you.
If it please the court, Richard Dolan for the respondents cross appellants. Let me just address very quickly the argument you just heard. The reality is that a claim for accounting was never in the case to begin with.
But aren't fiduciaries are entitled to an accounting?
If they demand it, yeah, the answer is yes.
But didn't they bring lawsuits? I mean, I know there are several lawsuits here between these parties,
Yes.
but they brought a lawsuit seeking the books and records.
Yes, they
and-
did.
And why would they not be?
The issue on this case, the only issue tried below was a demand for equitable accounting. And here's the order that Justice Cohen made granting them that relief. They wanted an immediate hearing, and he gave it to them. And he said, quote, on the petition for equitable dissolution, and I'm just leaving out the irrelevant parts, the issues to be heard and reported on shall include only, 1, whether equitable dissolution is warranted, 2, a fair and reasonable valuation of the parties' capital accounts, and 3, whether some remedy short of dissolution will be sufficient. And he did
But
that.
wouldn't an equitable dissolution and have to necessarily involve an accounting of the business, what's come in, what's gone out? I mean, it seems that that's kind of standard.
I think the answer to that, Judge, is no. And we quote for you the letter and the motion that Mr. Slarsky made below, where he said specifically, and let me just get the language, that he was not seeking any kind of damages. He was seeking to have, and he didn't want damages because he was concerned that that would imply a jury trial. And as you know, during the pandemic, there were essentially no civil jury trials. He asked for an immediate hearing on equitable dissolution only and for a determination of the capital accounts of the parties. And let me just find out where that is. I'll just read it to you because I think it's quite important. And the motion that he made that led up to that, and which ultimately the trial court granted, followed exactly what he asked for.
So you're talking about the August 2, 2019, where he asked for equitable dissolution?
Yes, that's the order. It's at A160 of the record.
But then he also asked for release of wrongly held profits, equitable buyout, and contribution and indemnification. Then they added a claim of breach of fiduciary duties.
But that's not what the court ordered a reference on. And I just read you the order, and here's what he said in a letter a couple of months before to Judge Cohen. Quote, petitioners are not seeking an award of damages that would attract the right to jury, but rather a valuation of the corporation's assets and a prompt equitable dissolution based upon the findings of the court.
And wouldn't again, you answered no before, but it would seem to me that an accounting certainly could be part of that if the referee said, well, in order to figure out an equitable dissolution, I need an accounting of the business.
It's never going to happen on the schedule they asked for. That order is August 3rd, I think, and don't hold me to the date. The judge ordered that all discovery, everything had to be finished by mid-September, and the hearing had to start 1st of October. You've all been trial judges. If that's not an accelerated schedule, I've never heard of one.
But at bottom, what's the reason that you say they're not, what is the reason that you say that they're not entitled to an accounting in this case?
A, they didn't ask for it. B, it's not necessarily part of an equitable dissolution. And C, the trial court and the referee went through each item.
But they did allege, does the accounting slide in, if you will, on their assertion of breach of fiduciary duty claims?
But that's not what got tried, Judge. It was only equitable dissolution with an express waiver of any claim for damages. I just read you the language, and it's a letter dated, I think, June 20th.
But if an accounting is part of breach of fiduciary duty, didn't the case ask for it?
It may, the pleadings never mention accounting. If they had asked for it.
They don't use the word accounting.
Yes, they don't. They don't.
They do use the word breach of fiduciary duty.
Yes, they do, Judge. And
So does that pass muster for them?
No, it doesn't, because they allege that as oppressive conduct that supports equitable dissolution. What they were alleging was oppressive conduct. The cases say they have to prove what they allege to be oppressive conduct, because under the cases in both the statute, to get dissolution, you have to show oppressive conduct. That's what they allege. That's what this whole thing was about.
But did they request a full accounting from the referee?
I didn't.
Did they ask the referee that they needed a full accounting?
They ask it at the end. The referee himself was working, again, with the same accelerated schedule as everybody else. He had been the receiver of the restaurant since, I believe it was May, and this is all happening in the fall. So he had personal experience running the restaurant. He knew the vendors, he knew the accounts, he knew all that stuff. He used his own experience in running the restaurant to address each item of oppressive conduct, which is this 42 million, it's now apparently gone up to 70 million. And it's at page 1225 of the record, if you look at his report. He goes through each and every one and says, some of these aren't proven and some of them are, and I find oppressive conduct. What happens then is that he balances, and now I want to switch, if I can, quickly to the cross appeal.
I just want to ask you a further question on this point. You said they're not entitled to the accounting because it wasn't asked for. But haven't we held in Coppell versus Wayne Lane that there is an absolute, where there's a fiduciary relationship between the parties, there's an absolute right to an accounting, notwithstanding the existence of an adequate remedy at law?
Yes, you certainly held that, Judge. What you haven't ever said, and this went to some of the questionings you've had from my opponent, is what is required in that accounting, okay? So certainly, as a principle, the cases you mentioned absolutely say that. But you have to ask for it, and you have to ask for it in a way that it can be granted. And that's what didn't happen here. And they were concerned about the fact that if you're looking for damages...
But it doesn't say you have to ask for it. It says if there's a fiduciary relationship, there's an absolute right to an accounting.
Well, you have, Judge, we all have absolute rights, but if you don't ask for them, the court's not going to do it for you. I think that's just, you have to plead it. For one, you have to ask the court to do it. Okay, and that didn't, and as I just, the court didn't order it.
Well, they're certainly asking for it now.
Well, it's a little late, Judge. This all happened to this, the hearing is over, the proof is in. That's essentially what, you know, and Justice, as your questions indicated below, when they raised this, the courts didn't say, they didn't rely on the point I'm making now. They said, there's no point to it. You got everything. In terms of the records he was talking about, the court held, the referee found they had all the paper records, they had all the records of the accountant who prepared all this stuff. They had 3 different sets of accountants looked at this.
Getting the records is not the same thing as getting an accountant.
No, of course it isn't. I agree with that, Judge. But you have to look at it in the entire context of what the case was, what they had asked for, and what they got.
So you have no obligation to substantiate the numbers that were provided?
No, no. The question is, we had an obligation to rebut or answer the claims of oppression that supposedly warranted equitable dissolution, and that's what we did. That's what this hearing was. And as I read you the order, the first issue is equitable dissolution warranted? It's warranted if you prove oppression. That's what they alleged. That's what the referee was supposed to hear about. Then, I haven't gotten to... On the cross appeal, Judge, let me just cut to the quick, if I may, and I know...
I'll give you 30 seconds. We'll have 2 minutes in rebuttal after.
Okay, Judge. If you look at the bottom line, what the referee said is to equalize the accounts. They get the excessive salaries we took for ourselves, 1.8 million. They get the salaries they would do for $840,000. That came to 2.6 million. At the same period, our guys got 2.8 million. At that point, and the referee said the difference was the historical difference in salaries. At that point, the capital accounts are balanced. They got what they got, we got what we got. Everything else after that should have been split. What happened after that is they awarded, the court ordered them the cash on hand, 2.8 million. 100% of the value of the entity, 5.1 million.
Weren't there unpaid distributions of 1.8 million?
If they are, then so are we. Once the capital accounts are equal, everything after that is the same. They got, all we got during that period was the 2.8 million bucks. The referee said they get 840,000 for salaries, and at 1.8 million.
But from 2015 to 2019.
Yes?
Petitioners didn't receive any distributions, right?
No, they didn't. And they were entitled to an equalizing distribution to what we got. We got 2.8, they got 2.6. The difference, the $200,000 difference, the referee said, is the historical difference in the fact that we got higher salaries because we were working at this restaurant and they weren't. That was it. Once they get the
Well, actually, only one of your guys is really working at that restaurant.
No, the one guy was there on a day-to-day manager, and the other guy was sort of overseeing the whole thing.
But his son was the...
Well, they were running the show, Judge. Somebody has to keep the vendors and all the rest of it in there. If you went in there and talked to the maitre d', that would have been the son. What happens, if you look at the award, we get 2.8 million over this period. They got about 9.1 million. There's no
All
way.
right, let me hear from, let us hear from the appellant, and you'll have 2 minutes afterwards, please. Thank you.
So how do you respond to your adversary's argument that you never requested an accounting? You requested.
I was going to start there, Your Honor. 828, paragraph 57 of the complaint requests, in light of the inequitable conduct, this is the first cause of action for equitable dissolution. In light of the inequitable conduct by Lakul and Tursanovic, the court should equitably dissolve Akin-Omled with a series of points of relief that we asked for, including 2, determining the amount of funds and the value of Akin-Omled property that has been improperly misappropriated and or diverted by Lakul and Tursanovic, and recharacterizing those amounts as loans to Lakul and Tursanovic to be repaid immediately. That's effectively an accounting exercise. Justice Friedman.
Really? Does it not? Could it not be read that the referee would make that determination based upon whatever information the referee had?
I don't think that you can determine the capital accounts without an accounting. Justice Friedman and Justice Kavanaugh referred to the Coppell case that's been recently reaffirmed in Mullen. It's an absolute and automatic right. Remember, this wasn't a claim for an accounting. We were asking for an accounting as a remedy. As a remedy, once breach of fiduciary duty was established and once we were entitled to an equitable dissolution, you necessarily have, that's why the court says this is an automatic and absolute right. Because in order to go through that buyout process or dissolution process, you need to go through an accounting. You need to know what the capital accounts are. The capital accounts can only be determined when you know where the assets are. If the assets have been diverted, if they've been paid out to somebody's farm in Croatia, those assets are treated as an advance against the capital account of the controlling shareholder. So that addresses that aspect. This is the first time I'm hearing, frankly, that we didn't request an accounting. It was requested in briefing in front of the referee. It was requested in front of Justice Cohen. They both expressly denied it. The referee said it would be pointless. He gave us an adverse inference based upon the destruction of the books and records, but then didn't give effect to the adverse inference. There is no benefit from the adverse inference. And just to finish the point out, round the point out, Justice Cohen said that the books are indecipherable. It cannot be the case in this courthouse that in a dissolution proceeding, the judge or the finder looks at records and finds that they are indecipherable, and that indecipherable records satisfy an obligation to account. It cannot be the case, Your Honor. Thank you.
Thank you. Mr. Dolan?
First of all, what was read to you, as Your Honor pointed out, is not a demand for an accounting. He was detailing the supposedly oppressive conduct that warranted dissolution. They have the burden of proving oppressive conduct. 2, that if there were a demand for damages, be it on a fiduciary duty claim or anything else, there would be a jury. Money damages lead to jury trials. That's exactly.
Well, they got a judgment. I mean, they got a judgment. So, I mean, that's for money.
All I'm saying, they got a judgment. For the reasons I say in my brief, I don't think they should. If you look at the $2.8 million that we got in this period, the $9.7 million, they got the $2.8 million in cash, the $5.1 million of the value of the restaurant, and the deficiency judgment of $1.7 million. You add them up, you're over $9 billion. We got 2.8. We're 50-50 shareholders.
Yeah, but the thing is, they found that there was oppressive conduct on the part of your clients, and that they stopped paying them. I mean, you were each 20. There were 4 people who were 25% owners, and even though you were running it, and you got some benefits for that, you stopped totally giving them anything for.
And we weren't giving ourselves anything either, other than the salaries.
No, didn't the referee find that you, okay, but you took salaries of $1,817,000 between 2015 and 2019 while they were receiving nothing?
Yes, absolutely, and they're entitled to an equalizing distribution for that, absolutely. And the referee gave it to them. And if you look at the numbers, he comes up with $2.6 million is what they're entitled to. They didn't get it. They absolutely entitled to that because we got the 2.8, and the difference is the difference in the historic salaries. Once that was done, the capital accounts were equalized. They got what they were entitled to. We didn't get more than the 2.8 million. That leaves the 2.8 million in cash, the 5.1 million that the restaurant was worth, and the 1.7 million they got on the deficiency judgment. You add that up, that's $9.7 million. They get 9.7, we get 2.8.
Well, just because, so what's that mean? Look, they got enough, that's the end of the day?
No, what it means, Judge, is that in an equitable distribution, once you equalize the capital accounts, that's what the referee was supposed to do. Everything after that is split 50-50, because we're equal shareholders. That's what should have happened, and it didn't. And it didn't because, as we explained in the brief, the trial court confused corporate debt with personal responsibility. The trial judge said that when you came to assigning the cash to them, you only count 50%. Why? Because they're supposedly really the owners of the cash? No, they're not. The corporation is the owner of its own cash. If the corporation owes you $100 and it pays you $100, that satisfies the debt.
I think we got everybody's
Okay, thank you,
points.
Judge.
We will certainly look through these papers again. Thank you both very much, and have a nice rest of the day. The last case for oral argument is 2015 Freeman versus Seneca Specialty. Good afternoon.
Good afternoon, Your Honors. May it please the Court, my name is Michael Lagnato, and I represent the appellants, 2015 Freeman LLC and 1941 Bay Miller LLC. What the appellants seek here is a reinstatement of their bad faith and punitive damages claims in this insurance dispute. The plaintiffs owned 2 former school buildings in Ohio.
Yes, we know.
Okay. The defendant Seneca Insurance Company used a scattershot approach in asserting defenses in this case.
Well, look, it seems to me that they investigated the alleged the losses, and they came up with a reservation of rights letter, very standard, right? And there were all kinds of different claims. I mean, are you disputing that you made some misrepresentations on this application, or that misrepresentations were made about the status of these buildings at the time?
There were, Your Honor, there were some inaccuracies in the.
I would call those misstatements, but you could call them inaccuracies. I'll go with that.
Yes, but the inaccuracies that were there, including such things as, was the building built in 1950 or 1929?
That could matter. That could matter.
Well, it could matter, but in this case, Your Honor, it didn't. One thing that needs to be remembered when looking at the material misrep here is the fact that Seneca Insurance Company does not have underwriting guidelines. So the investigator who's investigating the loss and he's investigating a material misrep claim, he can't go to a document and say, oh, this says that this is material. This says that this is important. We wouldn't issue the policy or we would change the premiums.
So you tried the issue of bad faith. I mean,
no, Your Honor.
Well, the judge granted a directed verdict.
Against us.
Right, against you. I understand.
Yes.
But you had to put in some proof, and then he said, look, there's no reasonable way this jury could possibly determine that Seneca did not have a reasonable basis for denying coverage.
Your Honor, he made a conclusory determination. It was
based on the evidence.
Well, Your Honor, we disagree. And this court had determined before trial, in affirming a motion to dismiss, that the defendant did not have sufficient evidence to dismiss the bad faith.
Well, that's really a different standard. I mean, we have that a lot. We couldn't dismiss it, we said in that case. I have a copy of that opinion, so I know that's what we said. But then you do discovery, and you go to trial, have a lot more information. Maybe you do, maybe you don't.
Well, Your Honor, understood. I don't think there was any difference in the evidence submitted on the motion to dismiss compared to what went at trial. But nevertheless, every single one of these defenses was dismissed. The same judge that dismissed the bad faith claim dismissed the material misrepresentation claim. All right? He found that these inaccuracies, misstatements, misrepresentations, whatever you call them, were not material. And he used Ohio law. He wasn't even using New York law. And Ohio law is even more difficult to establish materiality than it is here in New York. What we had here was...
It was Ohio law that controlled.
It was Ohio law that controls. So it was much more difficult on Ohio law. Ohio law says if it's not in the policy or it isn't incorporated into the policy, then you can't, it's not material. Okay? Here, it wasn't in the policy, so therefore it wasn't material. The adjuster, the claims representative, he didn't make any inquiry as to materiality. He didn't speak to the underwriter. He certainly didn't look to see about the policy because it wasn't in the policy, and he didn't say, oh, it's not in the policy. And he even at trial testified that all misrepresentations are material. That was his position. So even though he did, and the court said he did investigation generally, he didn't investigate that specific issue.
Well, let's turn to something specific. Whether something is vandalism or theft is certainly pivotal, because if it's vandalism, it's covered. If it's theft, it's not.
That's correct, Your Honor. But
So didn't Seneca take the position, look, what happened here is clearly theft, and yet you called it vandalism?
But Your Honor, there was vandalism here that's admitted by the defendant.
Well, that's what you got the judgment for. What the jury found was vandalism as opposed to theft.
Right, but they went beyond that to claim that that was a misrepresentation or a fraud in the submission of our damage assessment.
How about the fact that the lights, there was a representation that the lights are going to be shut off, and yet the lights were on?
Well, that's not something that was even claimed in the denial letter. And again, that defense was dismissed at trial by the jury. The jury didn't buy it. They raised, I mean, let's talk about something simple like the protective safeguards endorsement in this case that said that everything had to be, they went on and on. They claimed it in their denial letter. They raised it at trial. They fought it ad nauseum at trial. And it turns out that that endorsement doesn't even apply because it only applies to fire and theft. And there was no claim here for fire or theft. There was only claim for vandalism.
I mean, are you saying because the jury gave you a verdict, albeit a verdict which was remarkably less than what you had sought, that means that all of the defenses, all of the misrepresentations claimed by Seneca have no validity?
The jury found that. The jury and the court. The court dismissed a number of their defenses. It dismissed the material.
Yeah, but the question is, did the defendants have a good faith basis for denying the claim?
Well, Your
Not
Honor,
whether the claim is ultimately valid or not.
For my example of the protective safeguards endorsement, all you have to do is look at the endorsement and see that it doesn't apply. The judge dismissed it based on that grounds. That's your investigation. Read it and you see it doesn't apply. There's no vandalism claim. I mean, there's no theft claim here. How could it apply? They made claim. They made 7 claims of material misrep. 3 of them, all you had to do was take a look at the inspection report that the adjuster had gotten, that the underwriter had gotten. He would see they weren't misrepresentations at all.
Let's hear from the respondent, and then you'll have 2 minutes to respond to her. Thank you.
May it please the court, Kate McGuire-Tedrick for respondent. Your Honors, under Ohio law as well as New York law, in order for an insured to maintain a claim for bad faith.
After Seneca issues the policy, or after Seneca binds the insurance, does Seneca do an inspection of the premises?
An inspection was done of this premises, yes.
And at that time, one or some of the insureds were present for that inspection?
Yes.
So, and that's before the loss is claimed, right?
Yes.
Yeah. So if you're doing an inspection at that time, weren't you on notice as to the condition of the premises? And shouldn't Seneca have turned around at that point and said, gee, you made a lot of misrepresentations to us about the condition of these premises in procuring this insurance from us. We're going to cancel the policy. They're material misrepresentations. You didn't do that.
Well, there's a few reasons why, Your Honor. And that's because, as the testimony was at trial, Tony Stuffa, the underwriter, did not recall if he'd ever actually gotten a copy of the inspection report. Well, the inspection reports sometimes come in weeks, months later, and the underwriters don't get it and they don't get the opportunity to review it. We have no evidence at trial.
Is that an answer? I mean, the inspection is being ordered by you. Shouldn't you be charged with knowing what's in it with not weeks or months later, but within a short, reasonable period of time thereafter? I mean, this was your opportunity to say, hey, we've been tricked here.
Well, here's what's more, Your Honor. There's certain misrepresentations that can't possibly be known from an inspection report. For example, they put on the underwriting application that they had someone visit this premises every week. As you note, this was an Ohio loss, 2 Ohio losses.
But whether or not the lights were on, you would have known. Whether or not you could get access to the premises, you would have known. I mean, you were in a position, at the get-go, I understand you're well within your rights to say, we were tricked. But after you've done an inspection, it seems to me you should be charged with knowing basically what the inspection is about. And, to point to the fact whether or not the premises are being watched every week, someone's coming down to inspect every week. I mean, there might be a serious question about the materiality of that. But there wouldn't be a very serious question about the materiality of whether or not the premises are secured, whether or not they're attached to a burglar alarm, whether or not the lights are off, the general condition, whether there's water damage, what's the condition of the roof. All of these are things that you would know from the inspection, and shouldn't you be charged with knowing that, maybe not the day of the inspection, but a week later?
Your Honor, some of these items occurred from the date of inspection, from the last time anyone we know went into this premises, until July when the actual loss was. The fact of the matter is no one was there at the premises, even though we were told there would be someone. So water damage went unnoticed. Paint peeling from the walls went unnoticed. Lack of heat went unnoticed because no one was there.
All of that would have been noted when your inspector went down.
Our inspector was there on one day in January. Then for 7 months, no one was there to check this property.
Was there heat in January?
I'm not quite sure, Your Honor.
What about the fact that they said that there was no pool there, and there was? When they got there, say, oh, look, there's a pool. It says there's no pool.
Well, these are not the only reasons that Seneca denied coverage. These are some of the reasons that Seneca denied, and there are a myriad of them. And the fact of the matter is, while we did not appeal the lower court's decision based on a cost-benefit analysis of what the jury actually determined, we don't believe that it was true, that they did not have material misrepresentations. But the fact of the matter is there were multitudes, including fraud in the claim itself, and there was some blatant fraud in the claim that came out during trial. Their own expert and their own individual who provided their estimate of damages pointed out, point blank, that he submitted $8,000 worth of damages that are not included under the policy that he knew shouldn't get paid, yet it was still given to the jury. And now we know that this is, $1 million and a $2 million estimates. Whereas
That is a basis justifying your earlier refusal to pay the claim?
Yes, because we got that estimate before we denied. We denied based on fraud in the claim. That estimate was how much they asked Seneca for during the claim. So when Seneca finished its investigation, it was handed that.
Procedurally, shouldn't the judge have presented this issue to the jury, reserved decision on your motion, and presented this issue to the jury, and then make a decision on if he felt that this should be thrown out?
No, because there's so many reasons that Seneca had a right to deny these claims. And it's not that we have to prove that we were correct. We don't even have to prove whether or not we were negligent.
Just that there is a good faith basis for having denied the claim.
Exactly. We have to prove that we were reasonable and that we were not unreasonable. Now, in order to get punitive damages, you have to show actual fraud, malice, or insult under Ohio law, or a conscious disregard for the rights of others. There's been absolutely no evidence here that anyone from Seneca or anyone on behalf of Seneca behaved that way. In fact, at trial, if I may, the adjuster from Seneca that was hired, it was a local adjuster, and Appellate attempted to get something out of him that he was adjusting based on bottom lines and that it was bad for business. And what the actual third-party adjuster, the independent adjuster said,
He said that he disagrees that it would be bad for business. I'm going to call it this way, regardless of the circumstances. Even if it means the insurance company doesn't hire me the next time, I won't be a hired gun. Thank you, Your
But
Honor.
he testified to that effect to buttress his credibility, which it's a good point for him to make.
Well, there was no opposition to that. There was no attacking of that credibility there. And he further, he went on again, because he was asked again, isn't it his job to look for this despite it being bad for business? He said, I wouldn't be doing my job if I was doing such a thing. Would it be bad for business? It will from a standpoint that I'm not doing my job. I've got to point out all provisions that apply to a claim.
It's still, you agree to issue a policy, you send someone down to inspect, that inspection would show that a whole lot of things have been misrepresented to you, and then you continue the policy.
Under New York insurance law, we would have to have reviewed that policy we would have had to have reviewed that report within 30 days in order to deny the claim based on it. I'm sorry, I withdraw that, in order to rescind the policy or cancel the policy.
Well, this is guided by Ohio law, isn't it?
Yes, that's true, Your Honor. But nonetheless, we also don't have any evidence that we ever received this inspection report.
Okay. Anything else? All right, Appellant.
Just a couple of points. On the issue of the inspection report, although the adjuster testified at, the underwriter testified at trial initially that he didn't recall receiving it, when confronted with his examination before a trial testimony, he admitted that he had received it, that he had compared it to the application, and that he did not cancel or rescind the policy or change the premium. It should be remembered here, most importantly, the standard for bad faith in Ohio is reasonable justification. Reasonableness standard, as we all know, is generally a question for the jury. In order to defeat that, they have to provide that no reasonable jury could come to the conclusion that this was that these were unreasonable defenses. We believe that that Seneca did not satisfy that standard and that the court erred in making that conclusion. We agree with the suggestion from Your Honor that this is an issue that should have gone to the jury, and if the court disagreed and felt that there was no reasonable justification for the jury's determination, that it could have been overturned. And that's all I have. I thank you very much, Your Honor.
Thank you.